Now, there's a lot of discussion about changing the system for selecting judges because voters are unaware of judicial candidates. They rely on party labels to vote. Also, the high number of candidates on the ballot make it difficult to become an informed voter. I just voted yesterday, and I saw no less than 25 unopposed Democratic candidates on the ballot. Didn't know who they were, and I only had one choice. Alternatives include what's called merit selection, which is a blue ribbon commission that selects or solicits interest in a vacant judicial seat and screens candidates for that seat. In a retention election, a judge with no opponent runs in an election after serving a year to retain that seat. Judges are overwhelmingly white, male, well-educated, middle class, higher, and members of the legal profession. Women, African Americans, and Hispanic Americans are notoriously underrepresented. This lack of diversity undermines the legitimacy of the court. Solutions lack strong support. Some argue that there is low minority representation because minorities run as Democrats and Democrats tend to lose in Texas. I don't know that that's necessarily true in judicial elections. Judges are elected, but they do not always represent the electorate. The Texas judicial system is a hodgepodge of jurisdictions. With the passage of time, the Texas judiciary has become less efficient. This can be seen in courts at all levels, from the appellate court in the Houston area to the Anderson County East Texas District Courts. This is Ava Guzman, and Rick Perry appointed her the first Latina woman to serve in the Texas Supreme Court. She's a Republican, to fill a vacancy in the court. She was elected to a full term in 2010. And that's what happens to most judges. Civil cases and tort reform. Tort law refers to civil cases in which one person has been harmed by the actions of another. For example, medical malpractice. The Texas Supreme Court sets the tone in civil cases, which makes that court a political battleground, favoring or discouraging tort defendants. Today in Texas, the Supreme Court is sympathetic to the defendants, not to the plaintiff.
Tort reform. Both words would seem to require some definition for all but those steeped in the movement to achieve tort reform and those fervently fighting to preserve the status quo. So, what is a tort? The word itself derives from the 11th century Latin word tortum, meaning injustice. Tortum, springing from the Latin word tortus, meaning twisted. Tortus, in turn, comes from the Latin word torquere, meaning to turn awry or to wring. In American legal parlance, tort means a wrongful act or an infringement of a right leading to a civil legal liability. Modernly, tort law is thought of personal injury law. Tort law has been part of the American legal fabric since the United States' establishment, having been adopted as part of the British common law system. And so, in legal and political senses, what does the word reform mean? When legislative bodies want to enact legislation altering a legal construct, like tort law, they often title the bill that way. For example, the Tort Reform Act of 2017. The fact that the word reform is in the title of the bill allows its proponents the opportunity to presume that the reform is needed or necessary. Its opponents might argue that the use of the term is clearly presumptuous, as in their view, the construct needs no reformation at all, or perhaps only the slightest amount of reformation. In fact, many of them call this movement tort deform instead. The tort reform movement has been in existence for many years. Its development comes from industries that are on the receiving end of tort lawsuits, such as medical malpractice lawsuits, and the insurance industry, which pays the vast majority of the costs when a personal injury results in liability, often champions this tort reform. Personal injury lawsuits, as with virtually all civil lawsuits, have two principal components: liability and damages. First, liability must be shown. That is, it must be shown that a duty existed and that the duty was breached, meaning that the duty of one person not to physically harm another person must have been breached. Second, to recover damages, it's not enough that liability be shown. There also must be compensable damages suffered by the injured party. A simple example would be where Party A's automobile collides with the automobile of Party B. Party A had a duty to not unreasonably strike Party B's automobile if Party B was acting reasonably. That establishes liability. Collision resulted in Party B suffering damages to his automobile and perhaps a broken arm. Party A must compensate Party B for the property damages and the medical bills for the broken arm. There are many types of personal injuries, of course, from the common one just described to ones that are much more complex. For example, let's take the case of asbestos. In the 1920s, medical science began to conclude that working around asbestos could lead to asbestosis, mesothelioma, and other forms of cancer. Lawsuits from workers afflicted with asbestos-related diseases were filed, culminating in thousands of such cases coming to be associated with the multi-district litigation that has been headquartered in Pennsylvania Federal District Court for decades now, and which is still ongoing. Damage awards, settlements, and funds set aside by corporations and insurance companies for asbestos victims have amounted to multiple billions of dollars. The vast majority of routine tort claims are not frivolous and do not result in mega verdicts by juries, but tort reform components, mostly the large corporations in general and those who support them, such as Chamber of Commerce type organizations, politically conservative individuals, and Republican-controlled legislatures, believe that there's a long-running problem with tort claims. These perceived problems take on a variety of forms. First, there are those who believe that certain types of tort lawsuits ought not to be allowed or even filed, or that they should at least have some serious restrictions. An example being restrictions placed on the filing and conduct of medical malpractice suits by some state legislatures. Mostly, however, it's not the number of lawsuits filed or even the rulings declaring liability that prompts calls for reform from tort reform proponents. Rather, it's the amount of damages that are awarded by judges and juries where there are no legislatively imposed limitations. In other words, tort reform is about money. In the view of tort reform proponents, the filing of frivolous tort claims and excessive jury awards adversely harm business interests and the economy by causing fewer business startups and by causing business failures, thus depriving the economy of new and existing jobs. Tort reform proponents argue that these lawsuits drive up the cost of insurance premiums and other costs for businesses and professionals having to defend themselves against unwarranted claims resulting in huge damage awards. As a result, would-be entrepreneurs and business owners become hesitant to establish businesses and potentially expose themselves to tort liability. In 2014, Republicans gained control of the U.S. Senate. With the election of Donald Trump as president in 2016, a Republican president is now in the White House. And while there's been much talk in Congress of tort reform, so far it's been only talk, and no tort reform measures have yet been enacted. That is decidedly not the case in state legislatures, however. Most of the states passed some form of tort reform legislation in the 1980s. The clamor continues to end frivolous lawsuits by capping certain forms of damages and by other measures. Opponents of tort reform, on the other hand, argue that there is no reliable empirical evidence that the tort reforms that have been enacted over the last several decades have achieved any laudable purposes, such as creating and retaining jobs or significantly reducing costs. The opponents argue that the tort reform efforts that have been passed have allowed large companies to reap huge profits on the backs of injured persons. For example, opponents argue that corporations are not devoting as many resources to safety and injury prevention because under tort reform, it's cheaper for corporations to be less cognizant of safety and simply pay the capped and limited jury awards that come along every once in a while. The arguments on both sides are meritorious. For tort reform advocates, there have been abuses in the system, both in the context of the filing of marginal or even frivolous cases, and in the context of jury awards that have been approved by judges that are clearly grossly excessive under the circumstances. Although it should be noted that most of the time such awards are overturned or significantly reduced by appellate courts. On the other hand, there have also been clear examples of abuses by corporations in the context of knowingly committing torts. A third front has emerged, suggesting that while some tort reform may be a good thing, the present reform ideas are ill-conceived, and that reasonable compromise would be a much better idea. By no means is the battle over. As Republicans gained control of more state legislatures, more tort reform legislation is proposed. The current situation in Arkansas is an instructive example. In 2017, the Arkansas General Assembly placed a proposed constitutional amendment on the next general election ballot that will limit contingency fees that lawyers can charge their clients in tort cases and place hard caps on both punitive and non-economic damages. An interesting analysis was recently written by columnist Max Brantley in the Arkansas Times. The trial lawyers and Democrats will spend plenty in an attempt to stop what amounts to stripping the Arkansas Constitution of the right to a jury trial for damages. But perverse Arkansas, though no home to runaway juries or financially strained nursing home owners or doctors, is inclined to buy propositions that the Chamber of Commerce declares good for business. If being hospitable to business and inhospitable to workers was a ticket to economic glory land, Arkansas would be Silicon Valley, the Research Triangle, and the Johnson Space Center rolled up into one. The arguments rage on. To tort reform proponents, it's an economic and fairness argument. To tort reform opponents, it's a human and fairness argument. Meaning, why should a legislature pre-impose arbitrary and subjective limitations on damages suffered by individuals that it knows nothing about? Due to the inherent complexities of the argument, it will not be finally settled anytime soon.
Figure 9.2 shows the amount of civil cases disposed of by the Texas courts. And as you can see, district courts by far outweigh either the Supreme Court, the courts of appeals, or the county level courts. County level courts saw a little more than 100,000 cases. District courts saw well over 200,000 cases. Now, judges in Texas are elected but do not represent the electorate. Judges are not subject to redistricting. Judicial districts in Texas are a hodgepodge of jurisdictions. The number of judgeships on the ballots is overwhelming, and it is easy for voters to simply vote according to party affiliation. Texas has an integrated bar. Licensed lawyers must join the State Bar of Texas. To practice law, one must be a licensed lawyer. To be licensed, it is generally necessary to complete a Juris Doctor or JD degree at an accredited law school. The State Bar of Texas is both a professional organization and a government agency. Lawyer discipline can occur due to criminal behavior, failure to keep a client informed, or not paying out funds from a settlement. Enforcing ethical standards is the job of the Texas Bar. The State Bar of Texas webpage shows a variety of activities of the State Bar. Every lawyer licensed to practice in Texas must be a member of the State Bar. The State Commission on Judicial Conduct deals with investigating misconduct and disability with discipline of judges, and it relies on complaints from the public attorneys in the judiciary. Other than impeachment by the legislature or criminal prosecution of judges, the Commission is the only mechanism for regulating the conduct of a judge. Most actions involve private sanctions. Judges in Texas are elected in partisan elections. Voters often know little about judicial candidates, and voters often vote on the basis of party affiliation. Minority groups favor a reduction in the size of judicial districts to increase the percentage of minority judges. The most controversial issue regarding the Texas judiciary is the selection of judges. No major reforms have been successful in Texas. Now, how does Texas select its judges? The method of initial selection for state high court judges, most states have gubernatorial appointment through a nominating commission, and then you vote to keep the person in office. Other states have nonpartisan elections. States like Texas have partisan elections, but there are only 8 states that have partisan elections. States like California have gubernatorial appointment, and states like South Carolina and Virginia have legislative selection committees. So Texas has partisan elections. So does the state of Alabama. Other than that, the ones that have partisan elections tend to be up in the Midwest. All right, so they did a survey of who holds the role of a judge, and 77% of trial court judges are white, and 69% are male. Only 4% of trial court judges in Texas are black. 17% are Latino. Now, on the appellate courts, 85% are white, 58% are men, only 2% black, and 13% Latino. Now, 81% of Texas lawyers in 2015 were white, whereas 43% of the Texas population was white. 12.5% of Texas population is black, while only 5% of Texas lawyers are black. 38.8% of the Texas population is Latino, while only 9% of Texas lawyers are Latino. So Texas lawyers tend to be white men, and Texas tends not to be. So are attorneys and judges representative of the public at large? That becomes the question. Now this is figure 9.1 showing the structure of the judicial system. And again, we have the Supreme Court and Court of Criminal Appeals at the top, going to the Court of Appeals, 14 courts and 80 justices, going down to the district courts, then the county court level, then the municipal judges and the justice of the peace. In 2012, Democrat Keith Hampton ran against Sharon Keller for presiding judge of the Court of Criminal Appeals. Although he ran a fairly strong campaign, Hampton faced a major difficulty because Texas has more Republican voters than Democrat voters, and voters tend to follow party labels in judicial races because they don't know who these guys are. Keller defeated Hampton 55.5% to 41.2% in the general election. State Representative Ronald Reynolds supported the new barratry law in Texas, only to find himself in trouble for allegedly violating that same law.
In many cases, it is a crime in Texas for a lawyer or someone representing a lawyer to contact a person for purposes of legal representation if the person has not first requested the call or personal visit. The contact is not illegal if the attorney is not seeking payment or has a pre-existing professional, client, or family relationship with the person being contacted. If you witness something you believe to be improper solicitation or barratry, please get the name and phone number of the person making contact and report it to your local law enforcement authority or the State Bar Chief Disciplinary Counsel's office toll-free at 866-224-5999.
Table 9.2 shows the state Supreme Court elections in 2013 and 2014 with more than $1 million in contributions. And Texas had 4 seats up for election and had $3.6 million in contributions. Michigan has a partisan election system, and it had $9.5 million in contributions for 3 seats. Now, Justice Nora Longoria of the 13th Court of Appeals received a public admonition from the State Commission on Judicial Conduct due to her behavior during a traffic stop in McAllen. The criminal justice case was thrown out of the county court at law because of a lack of evidence, but she was still punished for her unprofessional behavior as an officer of the court. All right, that's the end of this particular lesson, and have a good week.